Good day everyone, I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is Garnishments, Levies, Subpoenas, and other legal notices. It's a great pleasure for me to introduce our presenter for today, Mark Swartz. Mark Swartz is an employment tax specialist with over 25 years of payroll tax experience. He has been an employment tax auditor with the state of California. I would now like to hand over the floor to the speaker. Over to you, Mark.
Thank you. Welcome everybody to today's audio conference on garnishments and other legal documents that demand the attention of payroll and HR managers. Garnishments especially can be pretty tricky, and the point with garnishments is if they're not done correctly and on time, then your employee's debt can become your business's debt. Our learning objectives for today, we'll talk about general guidelines, company procedures or best practices, if you will. And these are all about garnishments. We'll talk about federal garnishment law, order of priority, state law, bankruptcy, and what to do with protesting employees, because for the most part, garnishments do not make employees happy. Now, do they? Then we'll have wage assignments, payment processes, pending legislation, and then we'll talk about subpoenas, summonses, and other legal orders. Okay, general guidelines. So garnishments can be for taxes, child support, civil debt, etc., many other things as well. You should have a written process for how your payroll department handles wage garnishments. Okay, so 5 questions to ask yourself. First of all, is it your John Smith? So again, about is it your worker? Is the garnishment legal, right? Does the jurisdiction where it's from have that control? All right, so answer the form. Again, inform the worker. Should attach a memo from the payroll, which should let them know how much is going to be withheld from their paychecks if they get a standard salary paycheck. Now, you can help the employee, right? It's mostly just about negotiations, just about saying, look, you have until X date to call your debtor and work something out. Federal wage garnishment law comes from the Consumer Credit Protection Act. But Title III of the CCPA limits the amount of an employee's earnings that may be garnished and protects an employee from being fired if pay is garnished for only one debt. That's important, folks. Okay, so again, protection from termination. Oh, you have to check state law, by the way, on that termination thing. Some states will not let you fire an employee simply because they're getting money taken out of their paycheck, even by 2 or more. You have to check the state you operate in. Another rule of thumb to figure out whether or not their net pay is garnishable should be earnings are greater than 30 times the federal minimum wage for the pay period. Disposable income. For pay periods other than weekly, employers use a multiple of federal minimum wage, okay? So biweekly payments, $471.25 for semi-monthly and $942.50 monthly. If they make that or less, garnishments will usually not apply, except for child support. $217 a week, by the way. Again, child support has gotten a lot of leeway under the CCPA to collect what they need to on behalf of the kids. So here's an example of child support. Another example, employees' gross earnings in a particular week are $263. Another example, employees' gross earnings in a particular work week are $402. Another example, garnishment orders received after the second work day of the week. Another example, an employee paid every other week has disposable earnings of $500 for the first week and $80 for the second week of the pay period. Another example, an employee on a $400 weekly draw against commissions has disposable earnings each week of $300. So that's a commission example. Another example, pursuant to a garnishment order with priority for child support. So once again, on discharging an employee due to garnishment, again, one garnishment, you can't make garnishment the reason to fire them. Okay, so when does a garnishment start? Generally, a garnishment will start with the next paycheck following the receipt of the garnishment. Order of priority. Under federal regulation, tax levies are above child support order. Child support orders, so any other garnishments are after tax levies and child support are fulfilled. It says order with highest priority will be paid first under multiple ones. One of the garnishment orders for support, child support, or support arrears. that support order will be paid first. Can an employee come to you and say, look, I owe somebody money. I've agreed to pay him back. Can you please withhold $100 out of my paycheck and send it to so-and-so? That is called a voluntary garnishment order. Here's an example. Bankruptcy orders have priority over anything. When somebody goes bankrupt, folks, the court takes control over all of their income and expenses. So some state laws. And again, you always have to check the rules and regulations in the states in which you operate. States will differ in the following areas. Limits for support withholding. States rules on, again, what income is. State rules differ on whether or not the employee is required to enroll child in employer-provided health insurance. State rules differ on when garnishment starts. Okay, hold on, let's stay here. Some expect withholding on prior completed pay periods. About priority with current, got one in place. For the most part, it's going to stay in place. Fees. Can you charge a fee? State rules differ on non-support garnishments. Okay, bankruptcy. Chapter 7, different than Chapter 11 and 13. When somebody goes bankrupt, first of all garnishment orders stop. They will show you their filing for bankruptcy and the withholdings stop. Chapter 13, the court can issue income reduction orders instead of wage garnishments. Employees can always go to the debtor and try to work something out. If they do that, make sure you get a revised garnishment or you have to withhold what the original one said. You're mandated to follow the order, a legitimate order, as written. You can pay by employment funds transfer. There are centralized processing units that handle garnishments. EFT is faster and more efficient than paper submission. But in Congress many years ago, and it's still out there, the Uniform Wage Garnishment Act. Anyway, it would also create a procedure to encourage creditors to stop wrongful garnishments. So that ends wage garnishments. Let's talk about wage assignments. Payroll-related subpoenas. Subpoenas are nothing more than court orders for documents or information. An IRS notice of summons. That ends the slide presentation. Thanks again for attending, and everybody have yourselves a great rest of the week.
Once again, thank you, Mark. So that does conclude the session for today. Thank you everyone for participating. You may all disconnect now. Have a great day ahead. Bye-bye.